Picture.
Yeah, so
Oh,
that's the
it?
first
Oh,
slide. Yeah.
okay. I'm going back on mute.
No, that's okay. So we'll go ahead and get started here. So we'll move on to the second slide here. So the overview of what we're going to cover today. This course, it's generally intended that we go over the basics. And so, what I want to do is cover what are the different types of community associations, because everybody has, a little bit different type, and there's different rules that govern that. I'm going to get into the basics of the governing documents and why they're important and what's generally covered in each of them, and where you can find stuff. Number three, what are the different types of meetings and how do you legally take action as a board and an association so you can make some decisions? Number four, how do you enforce the governing documents? And number five, we're going to get to what I call Hirzel's hurtful mistakes to avoid, which is kind of like a series of common things that probably defy common sense, but I see a lot of people do from time to time, and hopefully I will help you avoid them so you don't fall into those traps. All right, so for the different types of community associations that we have here in Michigan, I guess just to kind of generally describe what a community association is and what I mean by that, I typically describe it as kind of having three different functions. So everybody understands that when you buy into one of these things, that there's a real estate interest, it's a home, it's an investment, everybody is concerned about maintaining property values and maintaining that. So that's fairly obvious. The other two things that a lot of people don't necessarily realize that they're getting when they buy into a community association, or what comprises it, is, to some extent, it's a form of, it's like a mini government. There are rules, that are similar to, zoning laws, for example, and you have a board of directors, and the job of the board of directors is to enforce those rules. And sometimes that's not popular, but the solution there is to change the rules if they're not popular, as opposed to not enforce them. And then the third component of that is also you want to make sure that where you're at, it's not a miserable place to live. And so there is a societal, a social component to all community associations. And what I guess what I mean by that is, to some extent, when you go to these meetings, and you're running the meetings, you have to keep that, I guess, the people component in mind, and how they react and how you treat them, because that's an important part of it. But, I guess if this were a three-legged stool, these are kind of the pillars that most community associations are built on here. The types that we have in Michigan, so we have, I guess, what I'm going to call four different kind of community associations. So we have condominium associations. So we have a condominium act here, and so those are statutory creatures. So there's a statute and there's rules in place in Michigan that you can create a condominium, and you have to have a condominium association. We have general homeowners associations, and sometimes master community associations that govern multiple communities that could be condominiums as well. We do not have a homeowners association act here in Michigan. For the most part, you're going to have some corporate governance rules that come from the Nonprofit Corporation Act. But for a traditional homeowners association in a platted subdivision, essentially what you're going to be looking at there is a situation where all of your rules and regulations, they're going to be set as a matter of contract based on what's in your declaration. We have co-ops here in Michigan. So co-ops are a little bit unique in that you buy shares of stock in a corporation, and that corporation owns the real estate as opposed to the owners. So those were all the rage in the 70s and 80s, but unless you're in New York, Chicago, or some other big city, they're not super popular around here, but they still exist. And then last but not least, we have my favorite, I guess, the oldest form of community association we have here in Michigan is we have summer resorts, that they also have their own unique statutory scheme. There are several hundreds of, I guess, of these. They're largely in northern Michigan and in western Michigan. They have 5 different statutes that, a lot of them were created in the late 1800s. And into the early 1900s. Some of them have been updated, and some of these laws I think are a little bit archaic and not enforced, although people tend to get excited when I tell them that there is still a law in the books that if you violate the bylaws, any certain type of summer resort association, that it is a misdemeanor and you can send that person to jail. So I have never seen that enforced, but a lot of people that are having bylaw violations often, think about converting to summer resorts for that reason. So that's kind of the basic lay of the land of the different types of community associations and the basic principles that we have here in Michigan. So I'm going to dive into now is the governing documents. We're going to go through the typical types of governing documents that you're going to have in a community association. So just to kind of, before we get into the specifics, I do kind of want to give you a general idea, because one of the common questions I get is, where do the governing documents fit in with all these different kinds of laws? So just as a general rule for a hierarchy, federal law, we have something called the Supremacy Clause in the United States Constitution. So that's going to trump everything. There's not a ton of federal laws out there that are going to govern community associations, but there are some. And the most common is that you're going to have the Fair Housing Act, which is going to basically cover requests for accommodation if somebody has a disability. So that's an important one. The FCC has certain standards that are out there related to antennas and satellites. We also have a federal flag law as well. So there's not a ton of regulation on the federal law, but if you have something in your documents, that sometimes you may not be able to enforce it or may need to make an accommodation or exception because federal law generally trumps all. Underneath federal law, you're going to have state law. And so that's essentially the different types of statutory schemes that I talked about, whether it's going to be the Condominium Act. We have the Michigan Nonprofit Corporation Act, because most associations are set up as nonprofit corporations, whether you're organized as a summer resort or a co-op. It is pretty much, if you're organized under one of those statutes, your governing documents are going to have to comply with them. The next thing that we have that we don't get into a whole lot is going to be municipal law. That typically, you're only going to run into issues with that, oftentimes related to, things that are going to fall under the zoning ordinance. So that's sometimes short-term rentals, parking, things like that. And so a lot of times, there'll be a standard that you can maybe rent out for, 30 days, in your governing documents. But there's no short-term rentals allowed or under the zoning ordinance, for example. In that particular circumstance, you're going to have to comply with the most stringent. The other area that I often see this come in is approvals for building. So people, they may try and argue, well, I got a building permit. But it's really a dual track. If you have architectural control restrictions, you have to get the building permit to comply with the zoning law. You also have to get approval from the association in that circumstance. So generally speaking, you can't put anything, that runs afoul of a municipal ordinance in your governing documents. But in most cases, these are going to be dual tracks where you would need to get approval and you're going to be governed by both. Then kind of in the hierarchy, you're going to get into what we call the Articles of Incorporation and your recorded documents. And so the Articles of Incorporation, that is recorded with the state of Michigan, Laura, we're going to get into that, but that sets up your corporation and tells the state of Michigan that you exist as a corporate entity, that there's directors. And so that really deals, I guess, with the corporate aspects of running a community association. Then we have the recorded documents, which in a condominium is going to be a master deed and condominium bylaws. You're going to have a declaration if you're a homeowners association, oftentimes, summer resort, that kind of thing. And so in those particular types of situations, the recorded documents, those are, along with the Articles of Incorporation, are typically on equal footing. They typically do different things because the Articles of Incorporation and some associations will have corporate bylaws that go along with that. That deals with corporate governance issues. The recorded documents essentially deals with the different types of restrictions, the rules and regulations. Under those documents, oftentimes you'll be allowed, or the board will have authority to adopt rules and regulations. What the law is in Michigan is that with respect to rules and regulations, you can only enact something, as the board, to implement something that exists already in the documents. And so you can't change the structure or try and use rules and regulations to do a backdoor amendment to something you don't like. But for example, if you have a provision in your documents that talks about collecting assessments, but you don't necessarily have a process for what happens when assessments become delinquent, you could adopt rules that, as to what happens at 30 days, 60 days, 90 days, as far as putting a lien on, giving it to the attorney, foreclosing, things of that. And that's implementing something that already exists in there. If, for example, the condominium documents were completely silent on late fees, you couldn't go adopt, a late fee of $100, a month or something like that. You would actually need to go and change the condominium documents in order to do that. All right, so the next issue that we have here are different types of entities. So for the articles of incorporation, most community associations, you're going to see they are organized as nonprofit corporations, and they're organized that way. We also have unincorporated associations. It's fairly rare, but sometimes you'll see a homeowners association that is not incorporated. We typically recommend you would be incorporated because it gives you a nice liability shield. If you're unincorporated and you're serving on the board, then you have greater personal liability exposure. The other things you're going to kind of look at in the articles of incorporation, most community associations, you're going to want to see that they're organized on a membership basis. And that essentially means that all the members, they get to vote for certain types of things. And we'll talk a little bit later about what those types of things are. I have seen a few that are organized on a directorship basis, but those are typically more of your charity nonprofit type of situations. And generally speaking, I only see people, I guess, put that in the documents or start, that way if it's an accident or it's not intended. And over the years, we've had to convert, a few of these directorship corporations into membership corporations. So the members all get a vote. The other thing to take a look at in articles of incorporation, your governing documents, is whether you're going to be a voluntary or a mandatory association. And so generally speaking, the articles of incorporation, they'll refer to a declaration. That declaration will essentially say, you have to be a member of the association or not. In a condominium, you do have to be a member of the association. All membership is mandatory. So if you're in a condominium, remember that. But essentially what you're going to be looking for here is, how you define membership and whether you have to be a member or not. Generally speaking, it is much more difficult to operate a voluntary association. It's very difficult to collect dues. For example, if people can decide whether they want to be a member or whether they want to pay or not pay. So, we do have some voluntary associations that we deal with, but mandatory is definitely easier. But for this particular document, hopefully you have it if you're serving on the board. If you don't, I've put a link to the website here, and I'll pass out the presentation, but you can essentially go to the LARA website with the state of Michigan, and they will have your articles of incorporation, any amendments to articles of incorporation online, and they will also have a copy of your annual reports. So each year you need to file, and it's typically in the fall, an annual report with the state of Michigan that says that you still exist. And you identify who the directors are and who the resident agent is. If you don't do that for 3 years in a row, they will automatically dissolve you. And then you'll have to spend extra time and money trying to, I guess, regain your corporate status. It can be done, but there could be potential issues if you allow that to lapse. So I guess if you didn't know what the articles of incorporation were or where to find them, or if you filed annual reports, I just go take a quick look at this website here and figure out what the situation is for your own association. All right, so for the contents of the articles of incorporation, typically what you're going to find here is the corporate purpose. So that's going to, basically say, who the members are, whether it's, the purpose is this, to operate, a condominium, a homeowners association. And it's typically going to outline what powers the association have. Some associations, particularly homeowners associations, may have more limited powers. Typically condominium associations are going to have extremely broad powers. This document is also going to define who the members are. And so sometimes you get into tricky situations. If somebody is selling property on land contract, technically you don't have a new owner until that land contract is paid off. And so typically in the documents, you will want to define who are the members, who gets to vote, who comes to meetings, who gets the notice. And so this document is going to define who the members of the association are. The other big thing that's important for anybody here that's serving on a board is limitation of director and officer liability. So we're going to talk about that a little bit in detail, but this document will identify what the standard of care is. And so if you have a developer or somebody who just basically filled out the form, shot it off to the state of Michigan and filed it, you probably have very little liability protections. Our statute here in Michigan, depending on what the standard is in this particular document, you can exempt directors and officers and volunteers for liability for pretty gross negligence and below. So pretty much as long as you're not doing some sort of intentional harm to the corporation, then there's a good chance that you could limit director and officer liability, since you guys are just volunteers there. But that will also be set there. Indemnification. And so this document, if you are sued and there's a situation where it's not covered by insurance, whether or not the association has to reimburse the directors, officers, and volunteers, and what types of circumstances they would have to do that, is going to be identified in this document. And then the last important thing that we typically see, or a reason to consider amending this, is an action without meeting. And so we're going to talk a little bit later about the different ways that you can take action, but besides actually getting together and voting in a meeting, which is often somewhat difficult to do and get enough people to attend, if you have a provision in your articles of incorporation that allows you to take action and vote outside of a meeting, whether that is through a ballot process, a polling location, anything of that nature, you can put that in this particular document as well. So these are kind of the key things that you're going to want to look for and make sure that are in your articles of incorporation, and that you just didn't get a form that somebody filled out that says, hey, we exist, and that the developer filed that with the state of Michigan. So with respect to the director liability issues, I do want to kind of go through a couple of examples and talk about how this potentially works here. So the first one that I have is that we have Joe. He's the president of Electoral Acres Association. The bylaws require the association to have 100% replacement cost for the property insurance. So that basically means if there was a fire or something, that no matter what the cost was, the insurance company has to replace it. Insurance agent advises Joe the current insurance policy does not provide coverage for 100% replacement cost as required by the bylaws. Joe and the rest of the board forget what the insurance agent said and vote to maintain the current insurance policy because it's cheaper. Fire burns down the condo building. The insurance policy limits $1 million, and due to inflation, the building now costs $2 million to replace. Is Joe liable for the $1 million? Anybody? I guess you can either go ahead and open up or put it in the chat if you have any thoughts on that. Oh. Sorry, looks like we. Oh, sorry, I got. Hold on just a second. I got some people in the waiting room here. Okay. Any thoughts on that one? Yes, yes. All right.
I think it would depend upon what the rules and what the articles say,
Okay.
That's all.
All right, so this one, I'm going to give everybody my favorite lawyer answer here is it depends.
Right.
And so we're going to get into that when I talk about, I guess, what's in the documents and also what may or may not be covered by insurance. But generally speaking, I'd say, if there was nothing in the documents and there's not any kind of insurance coverage, I think Joe's going to be in hot water in that particular circumstance because he avoided what the requirements of the documents are. But with respect to avoiding liability, what the Nonprofit Act says is that you can rely on professional advice. So whether that's an attorney, an accountant, an insurance agent, an engineer, anything like that. If you are reasonably relying on the advice of a professional, you as a volunteer officer and director are not going to be held liable for the decisions that you make. And we also have something called the business judgment rule. And essentially what that means is that the courts are not necessarily going to second guess business decisions. In that last example, if the governing documents did not require a certain level of insurance, then the court would not have, I guess, second guessed Joe's decision to only get $1 million worth of insurance as opposed to $2 million or 100% replacement cost coverage. But and so when you're just deciding whether you want to use a contractor, for example, and it has to, you don't necessarily go with the cheapest quote, a court is not going to hold you responsible for that. The key here is that you're entitled to rely on information, unless you have, personal knowledge that the information you're relying on is unwarranted. And so obviously if you know something that's not going to be true, you can't, rely on that, but otherwise, as long as you're acting in good faith and relying on the advice of professionals, you will not be held liable. The other key thing or the other important lesson here is to enforce the documents as written. And so in that particular example, the reason why Joe may have gotten into trouble is he did not review the documents and did not do what was written and deviated from that. The main difference here is in the Articles of Incorporation. You want to take a look at what kind of limitations of liability there are. So as I indicated, if there were no limitations of liability, I'd say at the very least, Joe was probably negligent or grossly negligent in that particular situation. In the articles, though, essentially you can exempt yourself from liability for anything except for these four things, which is a financial benefit that's improperly derived. So if you steal money from the association's bank account, you will not be able to limit, liability for that, or write yourself a big fat check. If you intentionally inflict harm on the corporation or the shareholders, if you intentionally commit a criminal act, or if there's any kind of attorney's fees that are imposed as a result of a failed derivative action. But other than that, you can pretty much exempt yourself from liability. And so just before you get on the board, one thing before I've ever served on any kind of a nonprofit board, I take a look at the documents and figure out, what I'm getting myself into and whether there's adequate protections there, especially because I know that you guys are not all getting paid a lot of money to do this. It's a volunteer position. Also on that note, these liability protections, they only protect volunteers. So while it's not super common, some documents do have provisions that allow officer and director compensation. We typically advise against that because you'll lose your volunteer status and you'll lose the liability protections that you have there. So the other thing before we kind of move on out of the Articles of Incorporation here, I do want to talk a little bit about directors and officers insurance. And so if you do end up in a situation where somebody files a lawsuit against you, typically what I find is most people, they don't look at what's in their insurance policy until after they got sued, and at that point it's typically too late. So it's much better that you have this kind of planned out and have an understanding of the different types of coverages that could protect you in advance. So generally speaking, for any kind of insurance policy, it comes with two things. Those two things are, number one, a duty to defend, number two, a duty to indemnify. So the duty to defend basically says if you get sued and there's anything that arguably could fall within coverage under the insurance policy, that insurance company, they have to appoint an attorney or they have to pay for an attorney to defend that claim. Because one of the biggest exposures in a lot of these lawsuits is just the amount of legal fees, even if you're right to try and get it dismissed. The duty to indemnify is a little bit narrower. So essentially what that says, it's not arguably whether or not it falls in coverage. It's when we get to the end of the case, do we have a claim that's covered and are we going to pay out on a judgment, if the court finds that the association did something wrong? So you definitely want to have all those different defenses in the documents that we talked about, but the directors and officers insurance is going to be the backstop to that. So I'm going to go through, I guess, another scenario here, just to give you an idea of what you should be looking for in your D&O policies. So Nancy and Chuck served on the electoral acre board with Joe. They claimed that Joe did not tell them the insurance agent recommended better insurance, and Joe misrepresented the insurance requirements in the bylaws. Joe tells them to pound sand, and he claims that they were not validly elected at the last election. Nancy and Chuck sue for $1 million for breach of fiduciary duty, and Joe sues Nancy and Chuck back, of course, to have them removed from the board. Anybody have any thoughts or ideas on whether, I guess, any of these types of claims are going to be covered by an insurance policy? So take kind of a look at, generally speaking, what most directors and officers policies are going to cover. So if there's some kind of a dispute about adoption of the rules, architectural control decisions, a decision you made about, raising assessments, somebody's claimed you breached your fiduciary duty in there, defamation, somebody says you said something stupid about them at the annual meeting, election disputes, failing to enforce the bylaws. These are all the general types of claims that are going to be covered, that are just routine types of decision making that, is going to be, part of your job as directors and officers. Where it gets a little bit sticky based on that last example is that not all D&O policies are created equally. So while these things are generally covered, there are potential exceptions, and depending on your policy, you may or may not have insurance. So one of them, and one of the claims that was in the example I gave you, is a claim for failing to purchase appropriate insurance. So some directors and officers insurance policies will provide coverage for that, and others will not. The other thing to take a look at is crime, employee dishonesty, and cyber insurance. Typically speaking, a lot of carriers will require, you to have an additional policy or only provide limited coverage for these things. That, if we once had a case where a director, he started a special fund for some construction defect litigation. And in the special fund that the property manager didn't have access to, he went and took about $1,000 a week at the ATM out of it. Fortunately, that particular association, they had, a crime insurance policy, and so they were able to get reimbursed for that. But if they would have had just kind of a bare bones D&O policy that kind of oftentimes will get packaged with your general liability policy, they probably wouldn't have had coverage for that, would have been in a bad spot. In addition to the crime and employee dishonesty, the cyber insurance deals with, people that may send a, email pretending to be the president to the property manager and telling them to transfer $50,000 into this, certain bank account. Those types of things, believe it or not, if you are a cyber criminal, are you going to be targeting the sophisticated bank that has all the firewalls, or the volunteer board members' emails that don't spend a lot of time, checking, that kind of thing in on it? And so, unfortunately, we have seen a rise in community associations being targeted by cybercrime. Defense costs for breach of contracts claims. So that's something that could potentially be included in a policy. The other biggie is discrimination and fair housing claims. If you have a good D&O policy, you will have coverage for that. Employment practices claims, if you have any employees. The other real important one that's based off the last example too is insured versus insured claims. So in that last example I gave you, we had board members suing board members. A lot of D&O policies will not provide any coverage if you have both people that are all insured under the same policy suing each other. If you have the insured versus insured exception, what that will do is the insurance company will pay for each side to get an attorney to defend them. And so, if you have to indemnify those people and you have the insured and insured versus exception, that can get very expensive for the association. And then the last thing to take a look at is non-monetary damages. a lot of these D&O policies will say that they only cover claims for money, but somebody may be suing you, to make you do something, or to force you to fix something, or say that they have a certain right under the documents, things of that nature. And so if you have a good D&O policy, it's going to cover that too. So I guess what I'd urge you, to take a look at, is talk to your insurance agent just to make sure that you have a lot of these things, because oftentimes when it comes to us, it's too late because you already have a claim and you can't change your policy at that point in time. But these are typically going to be game changers in dealing with a claim. All right, so that's pretty much what I'm going to cover on the articles of incorporation and director liability. Now we're going to go ahead and get into the remaining governing documents. So that's going to be the master deed, condominium bylaws, corporate bylaws, if you're a condominium. For HOAs, the restricted covenants, and the corporate bylaws, which are typically not going to be recorded. So this is going to be a lot of the nuts and bolts of how you're going to run the day-to-day operations of your community association here. So if you're in a condominium, the master deed, think of it like a deed, to your property, but except for everybody. So the key things that are going to be contained in the master deed, it's not necessarily going to be a lot of different types of restrictions, but you want to make sure that you have the appropriate legal description of the condominium. A few times we've seen somebody's made an error or mistake, and that's needed to be fixed. One of my favorite cases I ever handled also is about the correct number of units. And we did have a situation where a unit, it existed in the text of the master deed, but on the subdivision plan, all those maps attached to the back, it was not depicted there. It did not exist. And we had a fight about who owned it and whether they had to pay taxes. And so that was a big mess. Also, you're going to define what the common elements are and whether those are general common elements that everybody can use or limited common elements, and who's responsible for maintaining those. Those are going to be the big things that are going to be there. If there's an issue, who's responsible for repair? You're required to have the percentage of value, and so that has to equal 100%. And that can be important because the documents will either indicate that you vote in number, which means when you go to your association meetings, and everybody casts a ballot, if you have an equal percentage of value or you're just voting by number, that just means everybody gets a vote and it counts. If you have different percentages of value, what that means that those votes, if your voting is tied to percentage of value or your assessments are tied to percentage of value, they're going to be weighted. You need to make sure that you give appropriate weight based on that percentage of value. Easements, typically, whether you have the ability to use recreational facilities, whether other associations may have the right, to use your roads and you charge the money, things of that nature are going to be identified in there. And then they will typically have an amendment provision at the end, which is going to require 2/3 co-owner approval under our statute. There are 9 different things under the Condominium Act that also require mortgagee approval. And the most common ones that you're going to probably deal with if you're amending anything in the master deed and condominium bylaws is going to be a change in the maintenance requirements, or if you're going to be changing rental restrictions. Some documents will also have a developer consent requirement, or a municipal requirement. It's debatable whether or not that those are going to be enforceable. I mean, there is some case out there that says that they are. We have had a case recently where we had an arbitration, and the arbitrator ruled that essentially the developer, through the passage of time, they were no longer selling units, that they no longer had that approval right to amend documents anymore because they had stopped selling units and it had been 20 years. So that's generally going to be the contents of what you're going to see in the master deed or the declaration. For the condominium bylaws, that's where you're going to get into all the different nuts and bolts and the restrictions that people have to deal with in living next to neighbors and the rules that are going to have to be followed. So kind of what I did is I put up here the main ones that you're going to look for, and if the ones you want to make sure that at least you're familiar with. The one biggie is architectural control and modifications. Most documents will require some form of association approval before you can move forward and construct things. And you want to make sure that you have that, a clear understanding of what that process is. And if somebody is moving forward without following that process, that you take action to stop them. Believe it or not, one of the things I get, from a lot of boards is, well, they've already put it up and nobody's going to make them take it down, or, that would be crazy. But there was a case recently that came out in the last year up in the Traverse City area, and the Court of Appeals upheld the trial court's ruling where they made somebody take half of a house down because they built it in violation of the restrictions. Assessments, and so this is going to be an important thing. Typically in Article 2 of the condominium bylaws is going to be your assessment provision. You're going to want to see one, in your declaration as well. For condominium bylaws, you should typically have the ability to charge, late fees or interest, put a lien on, foreclose on that lien. For HOAs, you need to make sure that, you have a mandatory assessment provision in there. Sometimes they don't have the ability to lien, sometimes they don't have the ability to foreclose, but, that's something you need to take a look at. What the insurance requirements, that's going to be in here. Typically you're going to have the D&O that we talked about, a general liability policy, a property policy. I typically recommend that associations get a workers' compensation policy, even if you don't have any direct employees. If somebody's volunteering or going out to paint the fence or something like that, that there, could be coverage under your workers' comp if they're injured or hurt while performing that duty. And then the crime and the cyber insurance policy that we talked about. But also what the owner's insurance requirements are is going to be in here. Generally speaking, the trend you're going to see in a lot of older condominium associations is that the association was really responsible for ensuring everything, and that the owners, they were, they had optional HO6 policy that they could obtain. What we like to see in kind of in modern, documents is that if you maintain it, then you insure it. And so, typically this will save the association a fair amount of money on their insurance policy. And the reason being is that if the association has to insure everything, for example, if you get a situation where a co-owner, lights their deck on fire, and then you have a grease fire and, somebody has a toilet leak, and you have all these claims that are really kind of internal to the units, and you're replacing wall coverings and, cabinets and stuff like that. That all goes on the association's insurance, whereas, it's really related to the interior of the unit. The other thing that we see, a lot of times in that circumstance that makes it kind of difficult if there's an overlap between insurance and maintenance is when there's an issue, then they go take it to the insurance companies and the adjusters fight about whose responsibility is to handle it. And it takes a lot longer for the claim to actually get adjusted and fixed. And there's a lot of back and forth, as opposed to, if you just have a clear line down the middle that if you're responsible for repairing it, you insure it. And if there's an issue, it goes on your insurance. If the association is responsible for repairing it, then they're also, it's going to go on their insurance. Leasing and rentals, I can tell you this is one of the most hot button issues that we deal with. People either not notifying the association that they're renting, by renting in violation of some sort of a rental cap, things of that nature, short-term rentals when those aren't allowed as opposed to long-term rentals. But whether you have leasing or rental restrictions, that's going to be in there. Typically those are going to come in the form of some form of an express restriction. But here in Michigan, also, if you have residential use or commercial use restrictions, those can be used to limit rentals as well. Nuisance, smoking, and smells, you're typically going to have some sort of a provision that deals with that, whether it's odors from cooking, marijuana, people shooting off fireworks, cigarette smoke, marijuana smoke, any of that kind of stuff. So, you're going to have a provision there related to that. We have parking vehicles and towing. It's parking, whether it's on the street or whether you can have an RV or a commercial vehicle or anything along those lines. You're going to typically have restrictions related to that. You're going to have pets, whether you can have pets, whether they're going to be dangerous pets, whether they're going to be loud, whether you need association approval. And a lot of things we typically don't see, but we typically recommend updating just based on experience are going to be technology related. So if you have an older set of documents, it's It's probably not going to deal with things like drones, electric vehicles, Wi-Fi, whether you can bring your smartphone to the meeting and record everybody, whether you can create a Facebook page on behalf of the association and use the association's name, whether you can install solar panels, things of that nature. So, typically, if you have kind of the latest and greatest type of documents that are going to be drafted in the last few years, you're going to have provisions that are going to deal with that. If your documents are 20 years old, those things didn't exist at the time, so the drafter isn't going to contemplate them. And sometimes it can get a little bit sticky if you don't have a good enforcement provision and you have a problem. So that's kind of the lay of the land of what you're going to find there. So we're going to get into rules and regulations next. So give you another example here. So we have the Electoral Acres Association bylaws. They require the association to maintain, repair, and replace the limited common element front door of each unit. The bylaws permit the board to adopt rules regarding the appearance of the condo. The board adopts a rule requiring all front doors to be painted brown at the owner's expense. Mitch refuses to paint his front door brown. Association sues Mitch. Who wins? Anybody have any thoughts here? This is actually based on a real Michigan case, and I'll let you know how it ended up coming out. So, nope, he's a volunteer acting in the best capacity of his knowledge. So Mitch is actually the co-owner in this particular circumstance. Any thoughts on this one? Board wins, depends on the governing documents. All right, so in this one, basically what the court said here is that this was not a valid use of the rules. And so Mitch does win. And the reason here is that basically, while they could, the association had the responsibility to maintain, repair, and replace basically the front door. Okay. And so, they could say that they had, you have to have a brown front door, but then the association would have to pay to do that. They could not make the owner do that at their own expense. And so essentially by adopting this rule, they were making a structural change to the bylaws and shifting that burden from the association to the co-owner. And so basically what the court says is in this particular case, the proper vehicle to do this would be to amend the bylaws, not enforce rules and regulations. All right, so real quick, signs your documents need to be amended. There was some major changes to the Michigan Condominium Act in 2002, 2001, 2002. So if you have you're in a condominium association, your condominium documents predate that. In addition to not being able to keep up with technology, that's a common reason we see people amend. Also, if they have not been amended after developer turnover, typically developers draft the original set of documents for their own best interests, and they're not overly concerned about the long-term operations of the association and a lot of the issues you're going to have with the neighbors. And so we typically recommend taking out all the developer provisions and updating it then. Technology, if you're experiencing, issues that, are not contemplated by your documents, it's certainly a good reason to update. Another one, and my favorite one, is if your practice differs from the actual language, that's where I see a lot of people get into trouble. And so if you don't like something in your documents, fix it, as opposed to just, ignore it. Conflicting provisions and confusing. I am a firm believer that board members should be able to understand documents. They shouldn't be written by attorneys for attorneys, but they should be written for lay people so you can use them and understand them. I have seen provisions, in documents that, section 1 says one thing and section 2 says the exact opposite. So if you have some sort of a conflict or there's a fight over whether something means, you should probably at least update that. And then the liability provisions to make sure that you guys are adequately protected. All right. I guess one thing, and if you're also not sure as to, kind of where to go from this, one thing we do offer is we have a condo report card. And so with respect to it, that, it's something that we will give you. We'll go through all your documents, check yes and no boxes as to whether you meet legal requirements and best practices. So you at least have kind of a baseline understanding of whether your documents are good and you're good proceeding with them, or you may, need to budget, for an amendment moving forward. So. All right, so let's see, the next thing we're going to hop into here is going to be meetings. And so I'm going to kind of go over what the basics are as to what types of decisions are going to be made at annual meetings and board meetings. So the annual meeting it states under the Nonprofit Corporation Act, an association has to have an annual meeting once a year. If you have not had one in the last 15 months, a co-owner could file a lawsuit and have a judge order you to have one. The key things that you need to keep in mind at the annual meeting is that there's something called a record date, okay? And that basically determines whether somebody is eligible to vote. And so you as the board, you have the ability to make that determination. If you do not make that determination by default, that basically says that everybody meets the eligibility requirements the day before your notice goes out. That those are the people that can vote. One mistake I see people make a lot of times is they don't set the record date. People will be delinquent on their assessments. They bring a check to their meeting and say, well, here's my check. And my recommendation is to say, well, thank you very much. You're current on your assessments, but you are not, eligible to vote as of the record date. So unfortunately, we can't, count you in that situation. So it's important, to determine, what, I guess, who is eligible, to make sure you have the right people doing that. And then also notice provisions as well, and making sure that you get notice out in a timely manner. One of the things that I also see is a lot of people come to me and say, I got elected as the president at the annual meeting. And I have to often tell them, no, you didn't. What happens at the annual meeting is that you elect directors as opposed to officers. And what ends up, basically happening is that after those directors are elected, they go have their first organizational meeting, and then typically the directors elect the officers. It's very rare. I've only seen a few association documents over the years that allow the membership to actually elect the officer positions. So it's not impossible, but it's highly unlikely. All right, so board meetings, how does that differ from association meetings? So the typical types of decisions that happen at board meetings are going to be architectural approval. You want to make sure that you approve a budget for the year and base your assessments off that, determine how much should be held in reserve, entering into contracts, electing officers, enforcing restrictions, meeting minutes. Under most documents, almost all decisions are going to be made by the board of directors. And so these aren't necessarily decisions that you can then punt back to the membership. So under most documents, the membership has the ability to elect and remove directors. Oftentimes, if there's going to be a special assessment, which is something on top of either the regular assessment or an additional assessment, that there will be a vote of the ownership. And sometimes I've seen documents say that if there's the association is going to go it alone, there's the membership has to vote on that. But by and large, for the most part, most decisions that the association is going to enter into, those are going to occur at board meetings as opposed to association meetings. I have seen some board members, they will take votes, on these types of things to the membership, and they can vote on them or not. And typically that will just cause a lot of consternation because the membership will think that they then have the authority to make these decisions, when in fact they do not under the documents. So if you do want to get input from owners, I do it either in the form of an open forum or be very clear that we're just taking an advisory vote or a straw poll. Ultimately, the board will be making these types of decisions if it's not something that the membership is entitled to vote on under the documents. All right, so the board meeting, how do you actually vote at the board meeting? And I'm going to give you an example here. So Joe wants the Electoral Acres Board to approve a contract to install solar panels to reduce the association's energy costs and make up for his insurance gaffe. Joe wants to act quickly and proposes the following options: conduct the vote via email, hold a board meeting via Zoom, even though the bylaws are silent on Zoom meetings, provide Joe with proxies to vote an in-person board meeting if any other board member is unable to attend. Are any of these viable options? Any thoughts on this one?
Hi, Judy Lewis here. I think that it has to all be in person. I mean, it
Okay.
maybe Zoom might have been because of COVID, I get that. But it just seems that, especially to get the proxies, I know that's for the annual meetings, but for a board meeting, yeah, it's like a slippery slope, I feel.
Yep. So you definitely be sliding down the slope pretty fast if you took a proxy to a board meeting. So option number 3 does not work. So good call there, Judy. So you can't, proxies only work at the membership meetings. They do not work. Let's see. So they only work at the membership meetings. They do not work at a board meeting. So with respect to the first option, conduct the vote via email. So you could do it via email only if you had unanimous consent. And then what the Nonprofit Act says is you take all those emails where everybody approved them, and then you have to attach them to the next set of meeting minutes the next time you actually have an official board meeting. So that could be a viable option. The other thing is if you can't get unanimous consent, another option that you have is you can actually, vote via email, just with the understanding that it would need to be ratified at the next board meeting. And so you'd want to make sure that you ratified, that decision as long as there was a majority there and had a record and that was documented somewhere. The final option was hold a board meeting via Zoom, even though the bylaws are silent on Zoom meetings. So what the Nonprofit Corporation Act says about this, as long as that you can have some form of two-way communication, whether it's telephone conference, Zoom, or otherwise, and there's nothing in the documents that would prevent you from holding a meeting that way, that you are allowed to have that meeting. So, we typically, as a result of COVID and a lot of people meeting online, will put provisions in the documents, that deal with that, provide a process so everybody's aware how that works. But as long as you don't have anything that precludes it and everybody can participate, you can go ahead and handle it that way. So I did get a question I can go ahead and I guess address real quick now. So somebody said, should a board schedule a board meeting immediately following the annual meeting? And that was related to the election of the officers and directors, same day, later time. Most documents will indicate there's the board, doesn't have to give the usual notice requirements. A lot of, as long as everybody's there, the board members could meet right after the annual meeting. But most of them will say, as long as you have an organizational meeting within the first 10 days after the annual meeting, that suffices and you can elect officers at that particular meeting. So there should be a process for that in your documents.
Excuse me, should that be added to the rules and regulations that you can have Zoom meetings?
Yeah, if there was nothing precluding in it, in theory, you could, put something in there. You don't have to put that in the rules in order to have a Zoom meeting. But if you want to basically set, processes, as to how the meeting's going to be conducted online, you could certainly do that. You can either put in a bylaw amendment, or, if it just, your documents basically just said that you could hold board meetings, you wanted to adopt rules related to how you do that, via telephone conference or Zoom, you could certainly do that.
Right. Okay. Thank you.
Sure. So we're going to get into enforcement next. And so, typically when you have violations of the governing documents, there's a variety of different remedies depending on what's in your governing documents. So the first one is fines, and so if you're in a condominium, You know, a lot of times you will see provisions in the documents that permit people, you know, to be fined. You know, typically if somebody leaves their garbage cans out, you know, doesn't cut their grass, you know, things of that nature, a fine's a good remedy. If somebody is conducting short-term rentals in violation of the bylaws, you finding them 25 or $100 here and there, they're just going to build that into their rent and keep doing it. So it's not necessarily the best remedy. But typically for smaller violations, fines can be fairly effective. So you have liens. So if you don't pay your assessments, a lot of documents will permit the association to put a lien on the property and foreclose on that lien. Money damages. So if somebody, you know, violates the bylaws, you know, because they flushed their toilet 25 times and water went everywhere and they didn't have insurance, you'd be able to recoup any kind of money damages that the association had to pay for that. Injunctive relief. So that basically means that you have somebody make them do something or stop doing something. And so the example I gave before with short-term rentals, injunctive relief would be a good example to get somebody to stop renting. The other thing to take a look at is recovery of attorney's fees. Most documents will allow the association to recover attorney's fees, but not the owner. And some documents will allow the recovery of pre-litigation fees. Others will only allow the recovery of litigation fees. But most documents will allow some sort of recovery of attorney's fees. And the last thing, you know, with respect to enforcing the governing documents is you want to make sure that you have, you know, a bylaw or collection policy, which would be an example of rules. So you may have all these different, I guess, rules or, you know, in your governing documents. But, you know, the answer, you know, that you're going to need is how do I make sure that everybody gets treated the same? So there's no selective enforcement going on here. So you want to make sure that you adopt rules to create the same process that everybody would go through. See, we have a question here. It says, what if people ignore the fines or won't pay because they disagree? How do you enforce fines? Well, there's, I guess, a couple options. A lot of documents will say that you can actually assess the fines back to the owner. And if your documents allow fines to be assessed back to the owner, then what you can do is put a lien on the unit and foreclose on that unit. If your documents do not permit that, you will be able to recover money damages and sue them to actually collect those fines. All right, so quick example here on fines and how they work. So Hunter is an investor that owns 10 condo units and electoral acres. The bylaws prohibit rentals for less than 6 months. Hunter rents his units on Airbnb on a weekly basis. Joe instructs the property manager to fine Hunter $100 for each violation per the bylaws. Hunter does not pay the fine. The association places a lien for the unpaid fines as the bylaws permit automatic fines. Hunter sues to have the liens removed. Who wins? Any idea as to whether this was the appropriate way to go about fining here? So let's see, we have the association.
If it's in the rules and in the condo documents, it seems like the condo can do it.
So, so this one, it's actually kind of a trick question. So Hunter wins this one.
No.
Yep. So the reason why Hunter wins, and I see this happen all the time because people put stupid provisions in their documents, is under the Condominium Act, you have to have a notice and a hearing before you can impose a fine. And if you do not have a notice and a hearing, no matter what your condominium documents say, you cannot impose the fine. And I do see a lot of developers, attorneys that will just say, well, you can automatically fine somebody, or the board will just say, oh, it says we can have fines. And so we're just going to go ahead and start fining somebody. But if you come to me, I'm going to say, you're going to have to redo that all over again. And so for notice and hearing, typically what that means is that, you give them notice of what the violation is. A lot of times you can get a warning letter first under a lot of documents. And then, if they ignore the warning letter, then they can come to the meeting. Whether they show up or not doesn't matter. As long as you've given them notice, you can listen to whatever they have to say, and then you as the board vote whether you want to impose fines or not. And then they are obligated to pay those fines. Okay. So keep that in mind. that when you were finding people, it's not just a matter of firing off. So basically, the notice, the board actually, you want to document that in your meeting minutes. So I have a question here. It says if the association provides notice and holds a hearing, then they can impose a lien. So the answer is the notice and hearing is required to impose the fine. Once you impose the fine, some documents will say that fines are automatically assessed back to that unit, and that's okay, as long as the documents say that. If the documents don't have anything in them that says that the fines are not assessed back to the unit, then you would not be able to impose a lien.
And when you say a hearing, that means a hearing in front of the board of directors?
Yeah, so you can invite them, to your regular, board meeting and say, you're free to show up at 7 o'clock, and
Okay.
November 10th, and and a lot of times they won't show up, and then you can still vote to fine them, but you've had the hearing, you've made the decision. So there was another question here about is the hearing in an open or closed session? It doesn't matter how you want to do that. Generally speaking, in Michigan, we do not have the Open Meetings Act that applies to private entities. It only applies to public entities. So in order for you to actually, have a 1 hour board meeting, hour and a half board meeting, get stuff accomplished, I recommend pretty much having all closed board meetings, because then you'll be able to get through your agenda without interruption. And so I'd invite them, I guess in that fashion and do that. Typically, owners will want to know what's going on. My advice is that you would have an open forum amongst the owners and maybe do that on a quarterly basis, so they still have an opportunity to bring their concerns and voice their concerns. And it's a lot easier to get, make decisions that we talked about at the board meeting to get through the agenda. And not, have a 3 hour or 4 hour board meeting and debate every single issue, that a co-owner may bring. It's easier to kind of, gather them, at least in my experience. There's nothing that legally requires you to do it that way. But in practice, I've seen that tends to work best. So for liens and foreclosure, so Hunter's upset about the rental restrictions and stop pays assessments. Hunter has a unit that has $500,000 that's owed on his first mortgage. So what's the best course of action if the unit is worth $1 million? So in this situation, if you have a lien on, and there's, the unit's worth $1 million, you're gonna have $500,000 in equity in it. So what we would probably do is recommend foreclosing on that lien. Just because there's plenty of equity in the unit, it's likely somebody's going to buy it, but even if nobody buys it, the association can typically do a credit bid for what they're owed and end up taking that. The next question is what's the best course of action if the unit's worth $100,000? In that particular situation, the unit's going to be underwater. What we used to do during, I guess, the real estate, crisis, is we would still foreclose anyways and then just try and rent it out until the mortgage company came along and foreclosed out the association's interest. But the other option there, if you think the person is collectible, is to sue them and get a money judgment and garnish their wages, tax refunds, things of that nature. And then what if the mortgage was a second mortgage? So we have Mark and Sandy Sebastian who got the correct answer. They sent out their HOA lien trumps the second mortgage. So that's true for condominiums. So in our, other than the first mortgage of record, here in Michigan, the condominium lien is going to be superior for HOA documents. A lot of times they will have a lien priority provision that mirrors that as well. So, all right. So the next thing we're on to here is injunctions. And so it says the condo bylaws require board approval to alter the common elements. Hunter places a hot tub on his limited common element deck. Hunter hires an electrician to install a dedicated box to power the hot tub and general common element wall. Bylaws are silent on whether hot tubs are allowed. The Electoral Acres sues Hunter and seeks an injunction to remove the hot tub. Does Hunter get to keep the hot tub? So this is actually based on a real Michigan case here, but anybody have any thoughts on whether or not Hunter has violated the bylaws or whether his hot tub's okay?
definitely not okay. If it's a power and the element, a common, general common, that means if, depending, I mean, at least where I live, we pay the electrical bill, we split it between the 18 units, and that's like he's getting free electrical.
Well, yep. So you'd make a fine judge. You know, we call you Judge Judy, but
Thank you. I should get a show.
But anyway, so that's how the court came out. They said, look, the limited common element deck, you know, that's yours. You can put a hot tub on it, but you can't hook up to the association's electrical, and you can't modify that general common element without their permission. And so basically, you know, what the court did was enter an injunction against him to make him remove that because he had hooked up to the general common elements without permission. So good job,
I
Judy.
have a question.
Sure.
If the condo rules and regulations state that only on that limited common area, you can only put your outdoor furniture, et cetera, with no comment about a hot tub being allowed, would that then eliminate the hot tub?
Generally speaking, if you had something about, I guess, I don't think that they would consider a hot tub as furniture. It'd probably be
Right.
classified as a fixture. But certainly, you know, if it was just a limited common element area, oftentimes, you know, the co-owners are allowed to, you know, do what they want on the porches and patios, things of that nature. Sometimes there are restrictions as to what they can put out there. You know, we did have a case before, where we had to sue somebody and get an injunction against him because he was putting political flags up.
Yeah.
He liked drying his jeans over his balcony and everything else. And he would not want to
Ours
remove them.
says furniture,
Yeah. So,
whatever, no flags, no outdoor drying your
so
clothes.
yeah, it's generally not unlimited, but you know, if your documents don't prohibit furniture and they're not going to be plugged in, you know, to the common elements or anything,
Right.
you're probably going to be okay there.
Okay. No hot tub.
All right. So the last thing before we get into Hirzel's hurtful mistakes is money damages. So after a short-term rental business is closed, Hunter opens a recreational marijuana business. Condo bylaws prohibit illegal activity, but Michigan has decriminalized marijuana. Hunter plugs in his grow lights into the common element hallway to save some money. The Electoral Association's electric bill increases $10,000 next month. So a couple questions I have here is can Hunter grow marijuana, and can the association recover their $10,000? Anybody have any thoughts on this one?
The 10,000, I think sure as hell should be recovering that because it's a common area. The growing of the pot, that's a tough, I'm curious to hear about that one. I mean, yes, they decriminalized it, but I don't know what the marijuana laws in Michigan. I mean, it says you can, but it's you know, I think is it for your own personal use or?
That looks like for more than your personal use.
No.
Yeah,
No, what I was asking is if marijuana says you can grow pot just for your own personal use, then this also, he cannot grow it for his own, for having a business. That's what I was asking. I didn't know what I don't know what Michigan's final law is.
Yeah, Mark and Sandy Sebastian remembered our slide from earlier on about the hierarchy of laws and community associations. So can Hunter grow marijuana? So the answer to this, a lot of associations will just kind of take a lax, I guess, position on it. But generally speaking, you know, our advice is you put something in your documents so you don't have a fight about this. But in most documents will have a provision that says you can't do anything illegal. Okay, marijuana is still illegal federally, even though they don't do a whole lot to enforce that. The other thing I'd caution you about with marijuana is there's been a line of case law out there that, you know, typically if you are engaged in some form of illegal activity, even if it's illegal under federal law, that's going to be an exception to your insurance policy. So in these grow operations, you know, when it's burned down the building, then there's no insurance coverage, and that's also a big problem. Not so much a problem necessarily for CBD oil or something like that. But the marijuana smoke also does become a problem. But I guess whether he can grow marijuana, if you have a provision in your documents that says that you cannot do anything illegal, the answer to that would be no, in my opinion, because it would still be illegal under federal law. Under Michigan law, it's not necessarily illegal, but it is decriminalized, is the way that they say that. So, and how can the association recover the $10,000? So in this circumstance, he plugged into the general common element hallway. And so as a result of that, he was not allowed to do that because it was a general common element. Would have been a different story if he would have done it within the confines of his unit. But has increased the electrical bill $10,000, and so that would be a violation of the bylaws by him using that electricity, and the association could sue to recover it. So,
Question, would that
yeah.
be in the association bylaws, the condo bylaws, or rules and regulations about marijuana?
You're typically going to see that in the condo bylaws.
Okay, thank you.
It says no matter what the activity is, isn't using the common element hallway electricity a violation? And the answer to that is probably yes. I mean, if you wanted to have, throw disco parties or something every Saturday and we're using electricity for that purpose, you'd probably end up in the same result too. So, all right, Hirzel's hurtful mistakes to avoid, and then I'll go ahead and open it up to any questions anybody may have. So quorum. So electoral acres has 100 units. The bylaws state that quorum is 50% of the coners that are in good standing. All the coners are in good standing. 48 people show up to the annual meeting. The association proceeds with the meeting. Donald Bump Jr. and Ivana Fair election are elected to the board at the meeting by a razor-thin margin. Joe Susan says the meeting was invalid. Will the court order a new election? What if somebody made a motion to waive quorum? Anybody have any thoughts on how this one would turn out?
I think they would need a new election.
Okay. Any other thoughts? No quorum, no action can be taken. Yep. So those two answers are right. I've seen a lot of people where there's not quorum, they'll make a motion to waive quorum. You cannot make a motion to waive quorum because you don't have a meeting to
No
make a motion
quorum.
at. And so that's kind of the chicken before the egg. So Joe would win this one if he went to court because there was not a valid election and the court would order a new election. So a lot of times, what you'll see is if you don't have enough people come to the meeting, you can still have an informational meeting. It's okay to go through and tell everybody kind of what the financial situation is, recap the projects for the year, that kind of thing. Just make sure that you're not holding any kind of official votes or taking any kind of action or trying to elect directors. All right, audits and reviews. Donald Bump is concerned that Joe is mismanaging the association's finances. He demands that the association perform an audit. The board determines that an audit would cost $4,000 per year and that audit is not required by the condo bylaws. They obtain a compilation for $500 instead of an audit and send that out to the co-owners. Donald sues for an audit. Who wins? Anybody have any idea on how this one would come out?
I would hope it would be the association. I mean, I know we audit ourselves every year just so we don't have something like this happen. And then also, once you give your answer, I'd be curious if he, no, okay. I'm hoping the association wins that one.
All right, so audits are required by the condo laws. So that one is partially right.
We vote at the board or at the annual meeting to whether have an audit or not.
Okay. So yeah, I'll get into that too. So the way this one turns out, to some extent it depends. So if you are a condominium association in Michigan and you have more than $20,000 in revenue that you collect each year, you are required to have an audit or review.
Right.
You can go to the annual meeting and you can vote to opt out of that audit or review. Some documents will require you to have an audit. Some of them will say you can have an auditor review. So if your documents, require something, you're going to have to stick to that, as long as it's consistent with the Condominium Act. The one thing though, in this case, that would be a problem is that the board only got a compilation. So just so you have a basic understanding of what association financial statements are and what they look like. What a compilation is basically you take all your numbers, you take them to a bookkeeper, and they put them into a nice, neat format. They don't verify whether anything is accurate whatsoever. And then they basically just spit that back out. So that's a compilation. That does not, if you're required to have an auditor review it, that does not satisfy the standard under our statute. Next thing is going to be a review. And so essentially that will, at least at a high level, take a look to make sure that the numbers match up, that they all make sense, but it's not going to necessarily deep dive into every single expense and do a full-blown audit. So a lot of times you will be able to see, you can get a review done for like $1,000, $1,500 a year, and I'd say most associations will do that. It's also to some extent nice because it provides the ownership with peace of mind that there's no funny business with the financials, because I would say it's very rare that in my entire career that I've ever seen funny business with the financials, but it's very common that all the co-owners think that there is some kind of funny business with the financials, and so getting those reviews and audits done will certainly help you out there. The audits, those are pretty rare, but I mean, that's going to be pretty expensive. You're going to have the CPA go through and really dig in and they look at every receipt and make sure that everything matches up. So that's audits and reviews. So record inspections. Everybody always wants to see all the records and every little receipt, what's going on here. So Donald Bump wants a full investigation of the association's expenditures. He claims the board meeting minutes will demonstrate Joe forgot to pay the insurance bill in 2022. Donald attends the next board meeting and demands that the board email copies of every insurance bill for the last 10 years to him within 5 business days. Donald claims the Nonprofit Corporation Act allows him access to all the books and records of the association. So, I'm sure that you guys have probably encountered situations where everybody wants to see every single little record that you have here. So does the board have to produce the records in this circumstance? Any thoughts?
Wow, good question.
Well, if you didn't come here tonight, how would you handle this? All right, so.
I was going to say, can you ask, I guess if you have a management company, since they have all the paperwork, could it maybe be that they could, I don't know, get stuff from them?
All right, so just walk into the management company's office and have them open up the file cabinet and have them start digging through it.
No, because we get monthly financials. I mean, you just give them the last 12, they can see what we see every month. So we also make sure that our management company isn't screwing us over. So I would think that, yeah, let them go to let them go there and check them out.
So the way that this works, or just so you're aware, there's a document inspection provision under the Condominium Act that basically says the co-owners have access to the books and records. There's a more specific one under the Nonprofit Corporation Act. And essentially what that says is that you have to identify in writing a proper purpose for the inspection. So idle curiosity is not going to be enough to demand an inspection. And along with a proper purpose in this circumstance, for example, there would be no reason that he would need to review the last 10 years worth of insurance bills if he was only concerned about the 2022 bill being paid. There's actually a case for one of these inspection cases that came out. What the court said is that, this guy had asked for, everything under the sun. And they said, well, you couldn't possibly have any interest in all these votes and these other things that happened before the time that you were actually an owner here. And so this is not a proper purpose or a reasonable request. So with that being said, they have to identify a proper purpose for the inspection, identify specifically what they want to inspect and why, and it has to be something that's reasonably related to their interest as a shareholder is what the standard is. And so, obviously if there's, if the assessments are raised or something and you say, well, it's because we have a higher, landscaping bill, you don't necessarily need to give them, the 5 different quotes you got in every single receipt. But if there's something evidencing, how much was spent on that, that would be reasonable probably to inspect it for that purpose. If you do not, I guess, respond within 5 days as to whether you're going to permit the inspection or not, and they do have a proper purpose and they have sent it, to the right location, they can file a lawsuit for inspection, and the court has discretion to award them reasonable attorney's fees. So if you do get these types of requests, it's a good idea, to act on them quickly. Or if you're not sure what you need to provide because the co-owner has asked for 500 different things, certainly, talk to the attorney about, what should be provided and not provided. And, in some circumstances, the information, it's easier just to give it to them or email it to them. What the statute says is they're entitled to an inspection. It doesn't necessarily say that you have to email them or mail it all to them. There's very limited exceptions for that. So certain things like, the association's last financial statement, for example, they can get a copy of. But pretty much, beyond that, they're if they want to get something, they have to have an inspection. So.
Can I
All right.
ask a quick question though? If the homeowner association has to go to the lawyers, and of course you charge us for every minute, can we get that? I mean, can we make sure that the guy who wants to look at these things, that he has to pay the lawyer fees?
You probably wouldn't have to pay us necessarily, I guess, to do that. I mean, in some circumstances, people want us to be there, they're worried about it, but the statute does permit them, they can charge reasonable administrative costs back to them. Typically, we like to see that, in the governing document, so that's clear and there's not a fight about that. You can charge them copying costs as well, but what the statute says is they're allowed to take pictures, and so they can make their own, copies for free. But generally speaking, attorney's fees can only be, assessed back to a co-owner's unit, if there's some sort of bylaw violation. And so the record inspection probably would not qualify for that. Oh, sorry about that. All right, Fannie Mae and Freddie Mac approval. This is just, I guess a quick scenario. Electoral Acres is an attached condo with 100 units. The board has not raised assessments in 5 years or made any efforts to collect assessments. 20% of the units are delinquent 60+ days. The board has never had a reserve study. The roof leaks on the entire top floor. Air conditioning for the entire building doesn't work. Board has decided to build the repairs into the budget for next year, though. The question is, will Fannie Mae and Freddie Mac give people looking to purchase units in your building or in this condominium mortgages or not? Anybody have any thoughts on this one?
I would say they wouldn't approve it.
Okay.
I think you should just pass on me tomorrow and go get that checked out.
Any other thoughts? So on this one, the answer is no. So you can only have up to 15% of the units that are going to be delinquent 60+ days. One of the things that came out of the Surfside condo collapse is if you have a condominium and you have 5+ units that are attached in there, they are not going to lend if you have any kind of major structural deficiencies. Or structural repairs that have not been performed. I guess they've updated what their questionnaires are, and associations are having to fill these out. That also includes anything that's mechanical in the building, which would be the air conditioning in this example. So it's not enough that you would have the repairs being scheduled. But this is just kind of a good example of why you should do the right thing as far as collecting the assessments, especially if you need a community association loan. Or your reserves were underfunded, typically they want to see the association's delinquency be, somewhere between 5 and no more than 10%. So it's really important to make sure that, you don't have a lot of delinquencies that are 60+ days. And also that you're making sure that your reserve fund is adequately funded and that you are making repairs as they arise as opposed to kicking the can down the road. All right, the last one before I open it up to general questions here is fair housing. We have electoral acres. They have a basketball court and has recently had problems with nets being cut down. The board suspects teenagers of wrongdoing, of course. The board adopts rules requiring any minor under the age of 16 to be accompanied by a parent when using the basketball court. Hunter complains that the rule discriminates against families. Is Hunter correct? Anybody have any idea on this one?
I think he's right.
Anybody else? So he is right. So essentially what a lot of, there's been cases that involve tennis courts, and essentially the issue here is that they required a parent to attend. And so this would, if you had this rule, in theory, it would deny access to minors, and it would discriminate against co-owners that had families just because their parent wasn't present. So a lot of times you're going to have to make, neutral rules that apply to everybody. And so, for example, if this, if it were a swimming pool, and a lot of times you'll see that, under a certain age has to be accompanied by an adult, you'd have to create rules that, define whether somebody is a capable swimmer or could swim the lap of a pool. There was, this applies to lots of different things. I mean, there was a case, over on the East Coast, and they tried to have men and women's swimming hours. And they said that was discriminatory based on sex. So I guess a lot of these things may seem kind of common sense or innocuous, but you want to make sure that when you're enacting, I guess, rules that, have an impact, either based on sex, gender, families, minors, things like that, anything that would involve race, religion, anything like that, that you want to check with the attorney beforehand. Emotional support animals, anything related to disability, just because, you can get in a lot of hot water over that. And it's real easy for an owner to just go file an administrative complaint that you as the board members and association then have to deal with, under the Fair Housing Act. So those are my Hirzel's Hurtful Mistakes. I do have, if you're interested, on Amazon, a copy of Hirzel's Handbook, which basically just kind of outlines all the nuts and bolts and is an easy reference guide. I'm working on version 2.0 because this is almost two years old at this point. So it's still a good resource, but by the end of the year, I hope to have version 2.0 done. And I'm going to go ahead and open it up for questions for anybody that would like to play Stump Kevin for a few minutes here.
I do have a question. Of course, I've been very verbal. You mentioned that if our master deed and bylaws predate 2002, we need to have them amended with technology liability information.
Yeah, well, generally speaking, if they're pre-2002, there was just a lot of changes that occurred in 2001 and 2002 to the Condominium Act.
Right.
And so most of those changes, those legal requirements are not going to be in your documents. I would anticipate, though, that if you haven't done anything since then, you weren't dealing with Airbnb, marijuana, drones, smartphones.
But how about Wi-Fi and setting up a internet system for the condo? Shouldn't that all have rules about what it is?
Yep. I mean, there was actually, there was a case where, we typically recommend that, everybody has to use their own Wi-Fi. If you're going to have some sort of Wi-Fi, like in the, clubhouse or something like that, you want to make sure that people aren't, doing illegal activity, downloading, pornography there, that kind of stuff. There's actually a case where a guy, fortunately he was out of town, but somebody hacked into his Wi-Fi in a condominium, did a bunch of bad stuff. And he ended up being prosecuted for it, but he was able to, demonstrate that it wasn't him. So that kind of thing, it can happen. So if we want to set up our own internet system, should we have something in the condo rules or the master deed or the condo rules? Yeah, I mean, typically you should be able to do that in the rules and regulations, but to some extent, it will depend on what's in your condominium bylaws.
But it should be set up before it gets in process.
Yeah, I would recommend that. I mean, that's generally true for anything. That essentially, if you fail to plan, then you're planning to fail. And a lot,
Right.
let's say, my secret, where I make, most of our money is in litigation cases that a lot of them could have been avoided had people, planned ahead or updated their documents or contemplated a situation as opposed to waited until they got too far down the road. So.
Right.
Kevin, this is Mark. I got a question.
Sure.
Record retention, is there any resource I can go to find out how long we have to maintain documents such as meeting minutes, ballots, financials, etc.? I've been in the banking industry for 40 years, and there's been really no guidance from federal or state regulators on that subject. Is there anything in the condo law anywhere?
There are certain things, for example, like their mortgagee ballots, they have a specific provision that says that you got to retain those for at least 3 years. Just generally speaking, it really depends on the kind of records, certain things related to, if it's part of the condominium documents, if it was a modification request or approval, I would never get rid of those. You're always going to want to keep those on file. Insurance policies, you don't have to keep forever. I mean, as long as you probably have the last 5 or 6 years, you're good there. Tax returns, you're probably going to keep those 6 or 7 years. Probably after, 6 or 7 years old contracts, you can, get rid of, things of that nature. So it really depends, I guess, on, the documents themselves. So
does Hirzel have any record retention guidelines that they can share?
Well, I guess we have drafted record retention policies for community associations, and to some extent they vary a little bit depending on what they want. So it's we don't necessarily have a sample, but we have drafted those as part of rules for associations before.
Okay, so how do we go about getting that if we are interested in that?
Just shoot me an email, and I'm happy to assign it to somebody around here and get that going for you.
Okay. Because we just worked with Matt on updating our bylaws and master deeds, so we're going to be having a lot of ballots coming in.
Okay, cool. Sounds good. Let's see, Jenna, I think you have your hand. Oh, okay. Go ahead.
You mentioned electric vehicles, newest thing. My wife and I were discussing it the other day. Would we have to install our own through our electrical system to a charging station, or is anybody anticipating having a community-wide electric vehicle charging station?
Well, right now everybody's all over the map on this, and so I have some community associations that I would say they are way ahead of the game. They have installed the infrastructure to do that. They've made the decision we're either going to allow this on an individual basis and then have the co-owner, pay for the electricity, or we're going to have a communal system. It's been a few years now, but I was involved in a case before where the association didn't really have any policy and a lady in an electric vehicle, and they had a shared garage, and it was general common element electricity. And so then they agreed upon a certain amount, and then she paid that amount, and then they tried to raise the price on her, and she didn't pay that. And so then they shut off all the electricity in all the garages. And so she ran extension cords all the way from her garage to her unit, and then she eventually moved out. So I probably, it's kind of what I talked about before about, failing to plan. And that association ended up in the news, and then he spent like all these legal fees that they probably didn't, they just amended their documents or come up with some sort of policy beforehand. For installing the charging stations, if it's going to be within your own garage or individual unit, typically you are going to need to get a modification request for that, because it's going to involve tapping into the association's, electric charging system. And most people don't want to just, plug into the wall because it takes forever to charge. You want, basically the quick charges. So, my guess is most associations are going to be equipped to handle that, but I guess kind of the industrial grade, probably not so much. I guess the best advice I can give you, have a discussion with your board now, because I think there are going to be more and more electric vehicles, and figuring out, I guess, whether you can support that and how you want to support that, to suit the needs of your owners and your community is an important discussion to have.
And in which document should that be?
Generally speaking, we'll put something in the condominium bylaws about that. Is where it's going to go, and then a request. Right. If you don't have anything specific, a lot of times it will fall under a general modification request, though.
So, am I correct that any of these items that become more 21st, 22nd century, like electric cars and, internet access, et cetera, those should go in the condo documents first? Is that right?
Yeah, that's the best way to handle it. So
that's what I would think, because that's got a higher level of authority.
Yeah.
Okay.
It's also harder to change because with rules, they can oftentimes be changed from board to board. And so, when you have important policies like that, you don't want it to go back and forth every time there's a new election.
Right. Thank you.
Hello, how is everyone doing tonight?
Hey.
This has been very, very great. I love it. But
Cool.
One thing I need to know is about the directors. How do we go about doing the directors, and what's all that about? Because that's something new for me. Because how we voted on our board was we just sat in a thing and we just said you. Boom, that's our board. So I'm need to know more.
So typically what happens is when you have the annual meeting, you'll have a nomination process. So sometimes people will have to be nominated beforehand and submit candidate forms depending on the process the association sets. Sometimes people just raise their hand at the annual meeting, and when they say, hey, does anybody want to run for the board? And some unsuspecting soul that doesn't know what they're getting themselves into says yes.
Let's talk about this.
Okay, so that's you.
But I knew I had to do it.
Yeah. And so then what ends up happening is that they will typically elect directors. In a lot of situations, you'll have staggered terms. So they're only electing either two, if you have a 5-member board, like 2 directors, 1 year, 3. Some associations, you'll elect all 5, positions or 3 positions or whatever you have every year. So the co-owners, they will vote at that meeting. Sometimes I think the situation you described is.
So wait a minute. So we need to add directors to our ballot is what you're saying, or no?
So yeah, the people that you put on your ballot, they would be directors that are elected at that meeting.
Okay. Yeah. Okay.
And so then what happens is after you elect the membership, so when you have the big meeting and everybody there, you elect directors at that meeting. And so then those directors, then they get together and they do basically what you said, where they point the finger at each other and said, who wants to be president, vice president, treasurer? And so those are called the officer positions.
All right.
So they have separate and unique roles that are set forth under the documents. Not all documents say that you have to be on the board to be an officer. So sometimes you can be an officer but not be a board member. But most documents are going to say that in order to be on the board, you have to be an owner. So
ours is, yes. Okay.
Yep.
Okay. So
Okay.
we need to, our next meeting after we get voted in needs to be like, okay, we need to have directors to pick what position we're in.
Yeah. So you go and you say, I've been elected as a director. Now we're going to pick the officer positions. And
Perfect.
Then you see who's brave enough to say they want to be the president, is the way that it works.
Well, that's usually, I love our president. She is bomb.com, but I was just wondering how the process went. All right. Appreciate you.
Yep.
Thank you so much.
Absolutely.
I'm new, but I'm gonna make a motion to maintain the same officers that was there the last time.
that frequently happens too. People will get stuck in those positions for many years.
Yeah.
Well, that was getting ready to be my question. Can you hear me?
Yeah.
Oh, okay. I just want to make sure. I am new. That's why I'm not really talking much, because I don't even know how to ask the question, let alone understand half of what's been talked about. But it seems that most of the people on our current board have been in there 10, 15 plus years. And it largely is because they can't get this, what they're calling the quorum at the
Yeah.
annual meeting. So they just roll over and maintain the position. So I've been here a whole year, and somebody nominated me at the meeting just because I asked a lot of questions. And now I'm on the board. Do not know what I'm doing. So I have attended just about everything they've thrown at me, including all the materials. Most of them seem to be outdated or written in such a fashion where I can't understand them. So I guess that was one of the questions I had, because it sounded like you were talking about these positions have limits, term limits. But our people have been on there for years.
No, so I guess that's probably correct. So what the Nonprofit Act says is if you don't have quorum and you can't hold an election, the directors just roll over. And so they keep going until such time that you can actually get quorum and hold a valid election. What in the interim, a lot of times the board, if somebody resigns, they can appoint somebody who would then, go ahead and take that place. So if you didn't have quorum, but there was an opening on the board, the rest of the board, most bylaws are going to give them the authority to appoint somebody.
Okay, well, ironically, we apparently did have quorum. There were 2 positions open because people left. And I got nominated and somebody else got nominated. And now here we are, not knowing what we're doing and just getting a lot of stuff flung at us. And so I'm here because I think that was the title of this seminar.
Yeah, it was.
Judging from some of the responses that I've been hearing, these people some of them are seasoned because they seem to know what they're talking about.
I take it you accepted the nomination in order to be elected then, because you could have denied.
I did. But
you wanted to make a difference, so that's why you're here. You're here because you want to make a difference,
exactly.
And just keep learning and do the best for your community. That's how I feel.
And I wanted to understand things that apparently I couldn't get answers to unless I was on the board. So
Right.
I said, well, then seemed like everybody would want to be on the board. And so they said, oh, well, we nominate her.
Well, I mean, I think that's great because a lot of associations, they have trouble getting people to be on the board. And to some extent it is a thankless job because oftentimes you get paid in complaints, and you have to deal with a lot of issues that aren't that fun. So it's nice to see you're enthusiastic and you ran and want to make a difference in your community.
Well, I am enthusiastic and I do want to make a difference, but I'm not going to take a lot of poop. I retired and I'm trying to be settled and happy. I'm not trying to. I just left the job with, problems. So
Well,
anyway.
Linda, you're going to do great because you've got the right personality.
Yeah, and if somebody gives you too much poop, that's what I'm here for, to clean that all up. Okay.
Okay.
That's what I deal in with a daily basis, so you don't have to.
Oh, okay. Because I have lots of questions that I'm not getting answers to from the people that are supposed to be telling me. So be sure I have your number. By the way, do we get a copy of this presentation?
If you want a copy, just email info@hirzellaw.com and I'll have our marketing person shoot you a copy. And then if you want the video of it, probably sometime next week, it will be up on our YouTube channel too. So you'll be able to have access to that as well.
Say that really slow. Info who?
Info@Hirzel, HIRZELLAW.com. So it should be the same email that you sent or signed up or got a notification about the seminar tonight from. So if you respond to that one, we'll make sure you get a copy of the presentation.
Okay.
I have a quick question. We're only 17 units and there's only 3 board members. If it turns out that no one wants to sit on the board, what happens?
Well, your condominium will not get maintained. It will fall apart. Your property values will decrease, and eventually somebody will probably come along and file a lawsuit, and then they will appoint a receiver to run your community association, and then you'll pay somebody a lot more money to do that than you ordinarily would, and your assessments will go way up, and then you'll have to pay a bunch of attorney's fees for it to be monitored by the court.
Okay, I mean, that's why I'm back on the board, only because there's only 3 people out of the 17, and my next door neighbor left, so I said, okay, I've done it before. That's the only reason why I came back on. And it just, because it was sent out a few times, because we had quite a bit of turnover for a while. And nobody wanted to go on the board.
I mean, the best advice I can give you is if you're having trouble finding board members, see if you can get Linda to move into your community, because she'd be happy to do it.
I just moved here.
Linda, we're a very small, nice community in Royal Oak. Come stay with us.
Oh, I'll send my brother. He loves Royal Oak. He loves
Well, there's a few apartments being sold there. Tell them to come over.
Okay.
I love Royal Oak too. I
Yeah.
just moved from that area.
Yeah. So
Hi,
do we-
Kevin. I have a question.
Sure.
My question is, this is Angela Stewart. My question is, if the board changed the amount of time that we're actually sending delinquent homeowners to the attorney, if we change that and we only put in our newsletter, we put it in our newsletter 3 months in a row, should we have done that differently? Should we have notified the homeowners directly by a letter, letting them know?
No, generally speaking, you'd want to update your collection policy and the rules and regulations, and then those would have to be, sent out and communicated to the co-owners is probably the best way to do that. I'd have to take a look at your existing documents. I don't remember off the top of my head, I guess, what you have and if you have a collection policy right now. But if you do, I guess I would amend that. If you don't, I'd recommend adopting the collection policy, as the rules and regulations and providing that. And it's a good way really to get everybody on the same page. It avoids a lot of, well, you let this guy go on for this month and that kind of thing, or, I didn't have the newsletter, I didn't get the newsletter. It's going to give, I guess, some more weight in your ability, to enforce that. So
What if we started actually sending them to the attorney already?
Well, if they're already here, they're already going to be going through the process. I mean, the only thing that we could potentially do is pause that process. But if they were sent to us, because you had some rules in place as to, the time frame that they were going to be sent with the attorney, I would probably, stick to that if you've already started the process.
Okay. If there's not any more questions, can I ask one more?
Sure.
Well, if our developer allowed 2 homeowners to put a fence in their backyard and our developer is now gone, but our bylaws state that there are no fences allowed in our community, and a homeowner now wants a fence, what's the best way to handle that?
Well, I guess it'd start with whether you want fences or not, amend your documents to either permit fences if you want them. If your documents don't permit fences, I would not allow anybody else to have a fence. A lot of times the developer has discretion, I guess, in architectural control authority, so they may have granted, some approval there. But most documents will contain what they call an anti-waiver clause. And so essentially what that says is even if somebody may have violated the bylaws and we have not enforced it in the past, that doesn't mean that we can't enforce it in the future. And so, we've had several cases where people have said, well, 1 or 2 other people in the community have done this. That means that the rule doesn't apply anymore. It's been waived. And a lot of the case law on waiver in Michigan, I mean, there has to be a real substantial change. I mean, you would need, if you had 100 people in your community, like 60, 75 or something, that all went out and had fences for the court to say that restriction is no longer valid. So, if you only have a couple people, I would still enforce, that restriction is written, even if the developer did something wrong.
Okay, thanks.
Any other thoughts? All right. Well, thanks everybody for joining tonight. Feel free to shoot, respond to the email and request a copy of the presentation. And as always, we're here to help for any of your questions. So thanks for taking time out of your evening to join me tonight.
Thanks.
Thanks, Kevin.
Thank you very much.
Thank you, bye.
Bye.